number 10, Ferreira versus the City of Binghamton. Counsel?
Thank you. And, Your Honor, if I may please have 2 minutes for rebuttal?
You may, sir.
Thank you. May it please the Court, my name is Bob Jenis, and I represent the plaintiff appellant, Jesus Ferreira, and I tried this case. This is not a special duty case because of the judicially affirmed findings of fact established that the city's police department was negligent in violating required police standards of care and good and accepted practices in planning and execution of a no-knock warrant as conceded by the chief of police and others.
Counselor?
There was no exercise of discretion. I'm sorry.
Counselor, how do you get around Lauer?
Lauer is distinguishable on two different grounds. First of all, in Lauer, there was no direct contact between the medical examiner and the plaintiff. Here, there is direct contact between Miller, the police officer, and the Binghamton Police Department, and Mr. Ferreira. The second distinguishing feature is in Lauer, you have two different departments. You've got the Office of the Medical Examiner, and you've got the Police Department. Here, it's only the Police Department. This is the police, plain and simple. So that Lauer has
The court
nothing-
didn't make that distinction. The court said there's a special duty if a municipal employee causes injury.
Your Honor, but however, in Lauer, the injury here was far more attenuated. You have, what was the duty? The medical examiner has a duty to do with their discretion of how they do an autopsy report. Here, there was no discretion whatsoever. They violated required police procedures with respect, according to the chief of police, Hendrickson, the head of the SWAT unit. They failed to do what they were required to do. There was no discretion here whatsoever at all. They just said, mount up and go get it, boys. They did not have any discretion.
Now, do we have
Yes.
to agree with that characterization to find for you that they didn't exercise any discretion here?
Well, there's been a judicially determined determination of that. When the Second Circuit reviewed the findings of fact of the jury, unanimous jury verdict, that is what they in fact found. And with all due respect, this is a court of limited jurisdiction of law, not of fact. And here they sent you a certified question, a specific question, so that nothing else is...
But they always say in the certified question that we can answer anything we think helpful.
No. In the past, there have been other cases where they have asked this court, if you'd like to find other things, you're welcome to do so. Here, they asked a limited, narrow, specific question of law. They've already made factual determinations and upheld the factual determinations made by the unanimous jury.
Did the jury make, did the jury make anything other than a general verdict of negligence? Did they make factual, were there special interrogatories or anything like that?
Well, it was a general interrogatory. However, first of all, the city of Binghamton did not request specific interrogatory, so they waived it, and that the Second Circuit reconciled the verdict.
All I'm getting at is the facts that you're saying have been established are sort of an inference from a finding of negligence by the jury against the city.
Well, as the Second Circuit has the authority to do, to reconcile a verdict, as do the appellate courts in this state as well.
Okay.
In response to the first question you were asked about distinguishing Lauer, you said that there was no direct contact, and direct contact seems to be an element of a special duty test that involves other things like detrimental reliance and knowledge that harm can be done. That doesn't seem to play into your distinction here because you're claiming this is not a special duty case at all.
Correct.
So what is the significance of the absence of direct contact here?
The significance of absence of direct contact in Lauer or in our case, because in here we do have the direct contact, so I'm not following your question, Judge. I'm sorry.
Oh, I'm sorry. So you're saying that direct contact here occurred because the police officer entered the premises?
The police department has direct contact here because, yes, they entered the premises, and yes, they shot my unarmed client while he was lying in bed.
Okay, so my question is this. When you talk about direct contact, it's in the context of creating a detrimental reliance on the part of the plaintiff and establishing that the municipality had knowledge that harm could be done through certain action or inaction. And even if there is direct contact here, you don't have those other elements, or do you have those other elements?
Two separate issues, Judge. One can have direct contact and have nothing at all to do with special duty, or one can use it. It has two purposes. Here, the purpose is not to do with special duty. Here, this is not a special duty case. Here, there was, as the court found below, I should say in the Second Circuit, I shouldn't say below, that the issues of discretion have already been resolved. It was no discretion exercised here, so this court has a factual record where there is no discretion being exercised, there are no immunities, They violated required procedures. This is a Haddock case, plain and simple, and that special duty does not apply.
So just to follow up, the distinction that you're making with Lauer just is a factual difference between the two cases. It doesn't relate to the special duty question.
It is a factual distinction, Your Honor, yes.
And if I understand you correctly, it goes to, when you say it has nothing to do with special duty, it's a question of what the general duty the police have to people who are, let's say, innocent bystanders or happen to be somewhere where there's a police activity. And what you're asking us to do, I think, is to, I don't want to say, let's say, infer a common law duty on the part of police who are planning at least a no-knock warrant, but some sort of activity to, it runs to the general public. It's not a special duty.
It's not a special duty, however, there is a duty to the occupants of the home. And
Well, I guess what I'm
Ferreira
asking
was an
is
occupant.
it the same sort of duty that would also apply to a police officer who shoots in negligently and doesn't notice that there's a crowd of people that he's shooting into and hits a bystander? It's that same sort of duty?
Yes, but here it's even more controlled, because here they are intentionally, they know they're going to this house. They have a duty. This is not where somebody on the street
Well,
starts
yeah,
doing something.
I guess
and
what I'm
have-
getting at is trying to get at is the attenuation point, right? Because it seems to me you're distinguishing Lauer by saying, look, in Lauer, you said two things. One is there are two different parts of the municipality involved. Okay. And the other thing you said is that there was direct contact. That seems to me maybe makes a difference in terms of the type of duty you're trying to impose. But I don't actually see, maybe you can elaborate on this, how the officers who were in charge of planning had direct contact with Ferreira.
They set the instrumentality at launch. They launched the instrumentality of harm. And that is, they knew they were sending people out with no plan, with no intelligence. One of the things,
But isn't that
for example,
true?
Hendrickson
Isn't that
said,
same
I'm sorry?
thing? Isn't that same thing true of the medical examiner in Lauer? He set the instrumentality, he launched it. I mean, I take the point that it's a different, and maybe that has significance or not, it's a different arm of the government.
It's not only a different arm of the government, it's a far different thing. I'm a doctor, I'm doing an autopsy. That's a far different thing than saying, I'm a police chief, I'm sending 17 men with AR-15s into someone's home, not knowing the layout, not knowing who's there, having no surveillance. The cops themselves, they endangered their own police. That's why Miller, who was a good cop, had heightened danger, which was what Hendrick said must be avoided at all costs, the heightened danger, because that's why Miller, the door opened. All the other police that testified said that split second it opened, he shot because he's scared. He saw, the first thing he saw, he didn't expect to see it, so he shot. They put Miller in this horrible position, and that's why the jury found that they proximately caused the harm here, as affirmed by the Second Circuit. It's wrong what they did to the police. They endangered their own police. They didn't do any planning. They went in blind. Could you imagine being sent on an operation? You don't know if there's 20 guys there with submachine guns waiting to get at you. You've now spent a minute to try to break into this door because nobody planned anything, nobody brought equipment, nobody thought about anything, and now you're on up the creek.
Thank you, counsel. You'll have your rebuttal time.
Thank you.
Counsel?
May it please the court, Judge DeFiore and associate judges, my name is Brian Sokoloff, and I represent the city of Binghamton. First, the Second Circuit has invited this court, quote, to reformulate or expand upon the certified question as it deems appropriate to determine whether Ferreira failed to establish the city's liability for its negligence in planning the raid. There are two different issues on which the Court of Appeals, the Second Circuit, found New York law uncertain. One, they chose to ask a certified question, and the other, they chose to decide, but they decided it against the weight of authority from this court. And because these two immunities are interrelated, and sometimes in prior decisions, this court has gotten them mixed up, they're intertwined, I suggest that this court can deal with either or both of those issues. But let me start with the special duty issue.
Counsel, I'm sorry, I'm on the screen if I may interrupt you on that. Just to be clear, If the circuit viewed that within the confines of the rule regarding certification, that the only issue for which the panel could not be certain of the proper application of New York law was the special duty, can you clarify why, as you've just suggested, this court is free to reformulate under the rule for certifying the question, this other part where the circuit has, unless I'm wrong, you can correct me if you think I'm wrong, has not opined that it cannot properly apply its understanding of New York law?
I think the Second Circuit went out of its way. It did more than pose the certified question and say, answer us yes or no, like it sometimes does. It invited you to reformulate the question in a manner that frankly makes sense of New York law, and these two immunities are so intertwined, I think it would be proper for this court to deal with the discretionary immunity issue.
When you say deal with, counsel, you really mean correct them?
Yes.
Reverse their holding with respect to discretionary immunity?
Yes, and doing so would, in a way, make your job easier because it could defer to another day, perhaps the more difficult, the more uncertain issue of special duty. That would take care of the case, and it should have taken care of the case.
Can I ask you about special duty for a moment? Sorry, over here. As I understood and you should correct me if I'm wrong, as I understood your brief, had the officer gone in, closed his eyes, and just started shooting, you wouldn't say that there's any special duty requirement there. The municipality could be held liable for the officer's conduct, right?
I would say that the officer was in direct contact with the people in the house,
Yes.
knew that they were there,
Yes.
they knew that he was there, they were relying on him acting safely and appropriately. So arguably, I would say yes, that officer in that situation had a special duty.
Well, so, okay, so how about a crowd of people where an officer is chasing a suspect and shoots negligently and injures a bystander? Could you recover against the municipality?
So I would answer it this way. There's always has been, always until today, always been a special duty requirement. And you could argue about the facts of that case to say, well, there was or there wasn't, but it's always the plaintiff's burden to show
What would the special duty be in my hypothetical? Why doesn't that run to the general public? I mean, to take your prior answer, none of the people in the crowd know the police officer's there or aware of him. He might not have known they were there.
You know,
There are cases like that, right, where bystanders are shot.
it's true, and this brings up the earlier point. The court, to my knowledge, has not discussed your hypothetical in the special duty context because it's dealt with those shooting into crowd cases on discretionary immunity and said, well, we don't have to get to the special duty issue. So that's why they're intertwined. Now, this court has never, ever dispensed with the plaintiff's burden to show a special duty for negligence cases against the government acting in a governmental capacity like the police, and it should not do so here for two reasons. One, a jury has already determined that Officer Miller's shooting of the plaintiff was not excessive force and was not negligent. So if you were to find a special duty here, you would say that some unknown person, and that's a whole different issue, we don't know whose negligence this was, some unknown person didn't prevent the plaintiff from doing something that was legal,
But
constitutional, and proper.
Counselor, but wasn't there more than one police officer involved?
Yes, there were.
So couldn't the collective manner in which it was done, so couldn't you find that the jury could find as to the one officer, but still consider the overall manner in which the execution of the no-knock warrant took place?
Well, Your Honor, thank you for that question, and it brings up a very important point. this entire operation was not exclusively Binghamton employees. In the SWAT team, there were members from the town of Vestal and the village of Johnson City, or I might have the town and village reversed, but 2 other municipalities were part of it. And also, this was connected to an investigation by the Broome County Task Force, and that involved the Broome County Sheriff. The record here does not tell us who decided there wasn't enough surveillance, when it was decided, and most importantly, who that person worked for and what that person's job duties were. The record on that is a total, I'll say a mess. It's not a mess, it's empty. You can't use this case. It would be a mistake to use this case to create these kind of rules now that the plaintiff is asking you to do, because the facts are not there to support it. But let me go back to the second reason why in this case...
Counsel, I'm going to interrupt you on that just to clarify. But when you say that there were other municipalities, but wasn't, again, you can correct me if I'm wrong, isn't Binghamton's police department running the show?
The record doesn't bear that out. The record does not show, Judge Rivera, who made the decision we had enough surveillance. That person has not been identified, nor has that person's employer been identified.
Could I just ask as a point of clarification, that decision, whether we have enough surveillance, is that a discretionary decision, or is there really just one clear answer to that
It's
question?
totally discretionary, and they have not identified, the record contains nothing saying that it's mandatory. They did an hour of surveillance to make sure that the guy actually lives where they're going to go the next morning. But there's nothing that says you have to do 2 hours, 3 days, a week. You have to sit there to know exactly every person that's in the apartment, which, by the way, wouldn't tell you where everybody is exactly located, even if you knew, even if they did enough surveillance.
So, Counselor, are you saying that the police aren't required to make sure they know that the person they seek is actually present at the time that the warrant is executed?
It would be a good idea for them to do that, but I don't know of a legal requirement that they know that. They just before they went on this operation, they satisfied a criminal court judge that New York law and the Constitution were satisfied. A judge gave them permission to use speed.
And counsel, how far in advance of the actual entry did that determination occur? Which was based on surveillance that happened even before that.
The warrant was gotten at 3 o'clock in the afternoon. They went in 6 o'clock in the morning. So I'm not sure how much surveillance they would need to know.
And when did they do the surveillance before they went to the judge?
The evening before, like 8 to 9 o'clock at night.
So how many days had passed before they actually went in?
No. It was less than a day.
Okay. From the surveillance?
Yes.
I thought you said the surveillance was the evening before they went to the judge, and then the judge...
No,
the day
I'm sorry.
before Oh, I misunderstood then.
They got the warrant in the afternoon, 3 o'clock in the afternoon. 9 o'clock at night, they did 1 hour of surveillance. Their plan was to go in first thing in the morning, 6 o'clock in the morning, and that's what they did. It was all in less than a day. Now, this whole thing is premised on the idea, well, they didn't know that Mr. Ferreira was in the apartment. Well, Mr. Ferreira was visiting. What if he was in the apartment for 2 days or 3 days? Maybe he was sick and he didn't go outside. How much surveillance is a negligence court going to tell a police department you have to do before you execute something that a criminal court has said merits emergency action?
Counselor, it's an extraordinary power to be given the right to enter unannounced to a residential home.
I'm sorry, Your Honor, I didn't hear the beginning.
It is an extraordinary power to be given the right to enter unannounced to a residence.
Absolutely.
Would you not agree?
I would agree.
So I'm not understanding why there shouldn't be an expectation that there is responsibility involved with that power.
Because if you were to dispense with this, really what this involves is a question about the allocation of police resources. What this boils down to is alleged negligence that they didn't do enough surveillance. Nothing else was done wrong according to the Second Circuit. They didn't do enough surveillance. Now, if you're going to impose a duty without a special duty on the police, then you're going to do exactly what this court's cases have said courts should not do, and that is second-guess police on the allocation of resources.
Counsel, if I could reframe Judge Troutman's question another way, though, maybe the issue here isn't how much surveillance do you have to do before you'll say it's enough, but how little surveillance can you do before you say it's a complete abdication of your discretionary decision-making authority?
Well, and Judge, let me just point out, the alleged flaw here is not that they did bad surveillance. Didn't you see an infant going in? The officer was asleep in the police car. That's not real surveillance. That's not what they're saying here. They're saying that 1 hour was not enough. So how much?
No, but counsel, I mean, the surveillance that you're talking about, the last surveillance, is that the individual had left. There's no surveillance about him returning. Doesn't that go to sort of the quality of the surveillance? It's not so much about resources, but the value of the surveillance. I mean, if your only surveillance is the person left, they're not there, what are you doing going in until you confirm he's back? Or did I misunderstand the record?
When the police got there at 6 o'clock in the morning, he was already back. So,
They had confirmed that before they went in?
no, they didn't confirm that, but it wouldn't have changed anything.
So that's a fortunate circumstance.
Well, yes. I mean, had they stayed there till 2 o'clock in the morning when he got there and said, all right, well, now we know he's in there, that wouldn't have changed the outcome of this, not one bit.
Thank you, counsel.
They could have arrested him when they saw him, right? At 9 o'clock, at 3 in the afternoon, whatever time it was, 6, whatever time it was.
But there are already cases from this court that say that that's not a cause of action. You could have arrested somebody earlier.
Thank you, counsel.
Thank you.
Counsel, your rebuttal?
Thank you. Quick points. First, yes, Binghamton spearheaded this whole thing. Chief Sikorsky was in charge. It was a Binghamton operation. Two, one of the things he just talked about, he admits there was no discussion about the sufficiency of the surveillance because there was no discussion. There was no discretion exercised here. It was never even a topic. They abdicated absolutely, to use the word abdicate. Third, it's a non-issue because we already have affirmed facts by the Second Circuit that the jury found. In the special duty cases counsel was just referring to in response to your question about shooting into a crowd, special duty did not even come up in those cases, except in one of the cases in the context of somebody should have prevented an officer from shooting a third party. Here, we're not saying they should have prevented it. They actually caused the shooting. The last point is there was no, the Second Circuit did not ask for general appellate review. They asked for specific review on a specific certified question. Any other questions for me, and I'll gladly take them.
Thank you, counsel.